The first time I saw the containers, I thought I was looking at a mistake. There were 14 of them. Huge steel shipping containers lined up across the far end of my property. Blue, white, red, all packed tightly together behind a temporary fence. I had been away for almost 3 weeks. When I returned to my ranch, I immediately noticed the tire tracks. Then I saw the containers. I walked toward them and found an HOA sign attached to the fence. Authorized Community Storage Area. I stared at the sign. My property, my fence line, my land, and apparently, the HOA had decided to turn it into a storage facility. I called the HOA president, Karen Whitmore. She answered on the second ring. Karen, why are there 14 shipping containers on my property? There was a short pause. Then she said, Oh, those? Those? I looked at the containers again. Yes, those. Karen sounded completely relaxed. The HOA needed temporary storage. You needed storage, so you used my land? We've always considered that section part of the community's shared property. I laughed. You considered it? Yes. Did you ask me? No. Did I sign anything? No. Then remove them. Karen's voice became colder. We're not removing anything until the association decides what to do. I stared at the containers. What exactly is inside them? Community materials. That doesn't answer my question. It's none of your concern. That sentence changed everything. I called my attorney. He told me not to touch the containers. Don't open them, he said. Don't move them. And don't let anyone remove anything. I asked why. Because if the HOA placed property on your land without permission, we need to establish exactly what happened. So I documented everything. 14 containers, 14 serial numbers, photographs, video, GPS coordinates, even the tire tracks. Then I checked the county property records. The land was mine. There was no HOA easement, no storage agreement, no lease, nothing. The next morning, I sent the HOA a formal notice. I gave them 10 days to remove the containers. Karen's response arrived that afternoon. She refused. Instead, she sent me an invoice. Apparently, the HOA believed I owed them money for unauthorized interference with community operations. I stared at the invoice. Then I laughed. They had put 14 containers on my property without permission and were billing me. My attorney filed a claim for trespass and unpaid land use. We calculated a reasonable storage rate based on local commercial container storage prices. The number wasn't small. The HOA had occupied a huge portion of my property for months, and they hadn't paid a single dollar. Then something unexpected happened. The HOA stopped responding. For weeks, nothing. Until one morning, a truck arrived. A contractor stepped out and started preparing to move containers. I stopped him. Who hired you? The HOA. Do you have written authorization from the property owner? He looked uncomfortable. No. I showed him the court filing. He immediately called Karen. She arrived 20 minutes later. She was furious. You can't prevent the HOA from accessing community property. I pointed toward the ground. This isn't community property. Karen rolled her eyes. We've already established that. No, you've claimed it. She stared at me. What's the difference? Ownership. She had no answer. The case went to court. Karen arrived with the HOA's attorney. I arrived with mine. The judge reviewed the property documents first, then the survey, then the photographs, then the HOA's own correspondence. Finally, the judge asked Karen one simple question. Did the association have permission to store these containers on the plaintiff's land? Karen's attorney tried to answer. The judge stopped him. I asked the president. Karen swallowed. No written permission. The judge looked at me. Did you ever authorize the storage? No, Your Honor. Did you receive rent? No. The judge reviewed the storage calculations. Then he looked at the 14 containers. How long were these containers on the property? My attorney gave him the exact dates. The judge calculated the unpaid land use. The HOA had effectively occupied a large section of private property for months. Then came the twist nobody expected. The judge ordered the HOA to pay the accumulated rent. But Karen's attorney immediately argued that the HOA couldn't afford it. The judge looked at the containers. What is stored inside them? Karen hesitated. Community property. Such as? She didn't answer. The judge ordered an inventory. That was when everything changed. The containers were opened under supervision. Inside were expensive landscaping machines, commercial generators, power tools, event equipment, construction materials, dozens of brand new folding tables and chairs, even several pieces of equipment the HOA had purchased for future community projects. The total value was enormous. The HOA still couldn't pay the unpaid rent, so my attorney asked the judge for a remedy. The judge reviewed the legal claims and the value of the stored property. Then he made a decision. The HOA had used my land without permission. They had refused to pay the resulting judgment, and the contents of the containers were HOA-owned assets subject to the court's order. The judge awarded the contents to me towards satisfaction of the judgment, subject to the formal transfer and applicable legal procedures. Karen looked stunned. You're giving him our equipment? The judge corrected her. I'm enforcing the judgment against the association's assets. Karen looked at me. You want the containers gone. I nodded. I still do. But now you're taking everything inside them? No. I pointed toward the containers. Your association put those assets on my property. You could have paid rent. She had nothing to say. Within days, the containers were emptied under official supervision. The HOA's equipment was inventoried. The value was credited against the judgment. The containers themselves were removed. And for the first time in months, I could see my property again. The HOA later had to restructure its finances. Several board members resigned. Karen was voted out. And the new HOA board sent me a letter apologizing for the entire situation. The strangest part? It all could have been avoided with one simple conversation. They could have asked. They could have negotiated a lease. They could have paid rent. Instead, they assumed that because they were an HOA, they could simply take whatever space they wanted. They forgot something very important. An HOA may have rules. It may have a board. It may manage common areas. But it doesn't automatically own private property. Those 14 containers were supposed to solve the HOA's storage problem. Instead, they became evidence. Evidence that the association had been using my land without permission. And when the judge finally asked who owned the land, the answer was sitting right there in the deed. Mine.